Today we are going to watch a simple traffic case turn into a constitutional showdown. It begins calmly, but within seconds a defendant introduces sovereign-style language, calling himself a bailer and invoking equitable title. The judge immediately draws a firm boundary. This is criminal court, not civil. That first clash sets the tone. Ideology meets procedure, and neither side is backing down.
Good morning, Your Honor. My Christian name is Jose, and my family name is Elizondo. I am the bailior today, and respectfully ask some issues to raise.
Wait, Mr. Elizondo, wait. Jose Elizondo, I show that you have one case pending, and that is expired registration. Do you understand that's the charge that is pending against you?
Yes, I understand, but respectfully.
Okay, sir. Okay, hang on. There's several steps we need to take over. Were you able to hear my explanation about defendant's rights and options that I went over at the start of court?
Yes.
Do you have any questions about those rights or options?
Yes.
Go ahead. What's your question?
Okay, respectfully, I haven't received my documentation that I requested in a timely manner to proceed today.
No. What is your question? No, Mr. Elizondo, no. What is your question about the rights and options that I went over at the start of court?
I have no questions regarding that.
Okay, then to this charge of expired registration, actually, I'm going to stop and say, you mailed in payment.
I did.
You mailed in $3 and you have a balance due of $129. So with that payment of $3, we've already entered a plea of no contest for you because Texas law allows that to be entered for you. So we're set here to determine, are you able to make the balance of your payment by Monday, or do you need some time to pay that out?
Your Honor, respectfully, as a bailior and grantor, I've granted this court equitable title for settlement of any.
No, sir. This is a criminal court. No, sir. Mr. Elizondo, this is not a civil court. There are no parties like that in this proceeding. You're a defendant. You're not a grantor. I'm the judge, and so that does not apply to this court. You may have read that might be something in a civil court. That does not apply here. So my question to you, sir, is since you've already mailed in payment and indicated a plea of no contest by mailing in a payment under Texas law, can you get the balance paid by Monday, or do you need some time to pay that out, or do you have a financial situation that you need a financial packet?
Your Honor, for the record, respectfully, I am a Texas common law free man. I do not participate in corporate Ponzi schemes that require me to have registration.
This is not that, sir. This is not, Mr. Elizondo, stop. Mr. Elizondo, stop. This is not the time to make a statement. You see, we have like 12 other people who are set here. You're set on a criminal charge. This is not time for you just to go and make a statement about a civil matter that it is not set in this court.
So are you saying that I don't have civilian due process of law?
No, but this is not a civil matter. You're raising terms in regards to this as if this were like a civil lawsuit. This is a criminal charge where you've already. It's not
criminal, Your Honor.
Yes, it is, sir. This is a Class C criminal charge in Texas, displaying an expired registration. That is a Class C criminal charge, and you mailed in partial payment. So I'm trying to determine, are you able to make the rest of your payment by Monday, or do you need some time to pay it out?
I have the right to equitable title for this settlement or any charges on the doctrine of trust merge.
This is not a matter of a title to a vehicle or anything like that, sir. You seem to be confusing some civil law.
Well, I have some confusion because on Supreme Court case law Murdoch versus Pennsylvania, they clearly state that you don't need registration or insurance for private personal travel, and I don't consent to any corporate Ponzi scheme.
Okay, well, this is nothing to do with a corporation. This is a Texas charge, and you've already mailed in a payment for this. So you've indicated a plea of no contest. Are you saying that you're not pleading that? Then why did you give $3?
As a bailior and grantor, I gave
Mr. Elizondo, stop. Mr. Elizondo, stop. Mr. Elizondo,
of trust merge.
Mr. Elizondo, stop. Why did you mail in $3?
Because as a bailior and grantor, I have granted to this court equitable title.
Now the tension really starts to build. The judge asks a straightforward question about a $3 payment. But instead of a direct answer, we get doctrines, trust merges, and claims of corporate schemes. The courtroom dynamic becomes crystal clear. The judge focuses on statute and process, while the defendant sticks to principle. This is the moment where patience wears thin and authority takes control.
For settlement of any
No, sir, we do not settle.
charges
Sir,
under trust
Mr.
merge.
Elizondo, there's no party in a criminal charge that's called a bailer, and you cannot claim a position that is not one in this court.
Your Honor,
There's
are
no
you giving
status
me-
of bailer.
Are you giving me finance?
No, sir, listen, I
Oh.
need you to listen to me. I need you to listen to me. There's no status of bailer or grantor in this criminal court. You may have read some cases in regards to some other matter. You are a
Can you give
defendant.
me-
No, Mr. Elizondo, you need to be quiet and listen. You're a defendant. You mailed in $3, which is partial payment of a total of $132. All right. Now, by law, when you mail in a payment, a plea of no contest is entered. All right. So my question to you was, when you mailed in the $3, was that your intent to make a partial payment, requesting a payment plan, or were you attempting to post a bond?
My intent was, like I said, I am the bailor and grantee. I have granted this court equitable title for settlement of any charges under doctrine of trust merge. That's my answer to your question.
Okay, that is not an answer that applies in criminal court. So based upon your payment of $3, the court has already entered a plea of no contest, and I'm going to order that you get the balance paid
Your Honor,
within 30
respectfully.
days.
Okay, Your Honor, respectfully, with those documents that you have, I didn't receive any documentation requested in a timely manner to proceed today. Outlining my full warranto under Chapter 66 of Texas Civil Practice Code, which
Okay,
is
stop,
provable
Mr. Elizondo,
and
Mr. Elizondo, stop. The Civil Practice Code does not apply to this courtroom. This is the Code of Criminal Procedure applies to the criminal courtroom. So the Civil Code does not apply.
But I still have a civilian due process, Your Honor.
Well,
And I
yes,
have not
but
entered a plea.
you did by mailing it in. By mailing that in, that's
Here's where things escalate from minor citation to full courtroom battle. The defendant flips from no contest to not guilty and then locks in a jury trial. That single decision raises the stakes dramatically. He doubles down with motions to dismiss, leaning on transportation code arguments. The prosecution responds cleanly and precisely, and the judge denies the motion. The path to trial is officially set.
entering a plea of no contest. You mailed in a payment of $3.
Your Honor.
You can
Like
get
I
the
said,
balance paid.
The reason why I did that as a bailor and grantor, like I stated multiple times, I've granted this court equitable title for settlement.
Okay,
under
Mr.
any
Elizondo.
document plus merge.
Mr. Elizondo, were you wanting to plead not guilty and request a trial?
No. Respectfully, Your Honor. Constitutionally, too. For the record, I am a Texas common law free man. I do not participate in any Ponzi schemes that require me to have registration and insurance. I do not consent quasi-jurisdiction. Respectfully, Your Honor, I plead for a civilian due process of law.
Okay, well, you're
Under
receiving.
Section 1, Article 10.
Okay, Mr. Elizondo, you're receiving the exact same due process that every other person who's appeared in this court has. And you have mailed in a payment of $3, and that payment is received as a plea of no contest.
Who is my accuser, Your Honor? Respectfully.
The state of Texas. That citation that you received, that is the accusation. And
Okay, well, I would like to go to trial for this.
so you're indicating that you wish to change your plea from no contest to not guilty?
Yes.
All right. And you wish to waive your right to jury trial, or do you wish to request a jury trial?
No.
So no jury trial. You wish to waive your right to a jury trial?
1 second, please. Never mind. Give me a jury trial, please.
So you wish to request a jury trial?
Yes.
And you will be representing yourself, or will you be retaining counsel?
Myself.
Okay. Do you understand that if you request a jury trial, if you're found guilty, in addition to the regular state court cost, there is an additional jury trial court cost that's assessed if you're convicted. Your case is going to be reset for a pretrial hearing. That is going to be for our May contest docket, which is at 6 p.m. on May 7th. Show your video.
I'm here.
Okay, thank you. So, Mr. Elizondo, you had a pretrial hearing earlier this year in May, and then at that hearing, you had indicated that you had mailed in a motion for a bond, and that was the only motion that you had, and we did not have that here. After the court, and we set your case for a jury trial on August 28th. Then after the date of your pretrial hearing, we received a motion in the mail stating defendant's Rule 91 motion to dismiss for failure to state a claim upon which relief can be granted. Mr. Bishop, have you received a copy of that motion?
Your Honor, and made a response.
Thank you.
I believe he's filed two motions. I've got a motion to dismiss and then a motion, no consent given motion.
Yes, that's correct. All right. So, Mr. Elizondo,
A no consent given motion. Oh, this is good. I haven't seen it yet.
if you wish to summarize your argument, you may do so at this time.
Yeah, I just want to know, do y'all enforce the Texas Transportation Code?
No, sir, we're not answering questions. You need to summarize your motion at this time.
All right, well, I just want to add to my motion that according to the Texas Transportation Code, Title I, Section 502.003 clearly states it prohibits political subdivisions from requiring registration, and my violation was due to registration. So that's all I wanted to add, and I plead not guilty and for dismissal too.
Mr. Bishop, your response?
Yes, I addressed this in my response, Your Honor. The city of Dalworthington Gardens is the political subdivision of the state of Texas. And this registration requirement is not a violation of a city ordinance. There is no city ordinance that requires individuals to register their vehicles. That's state law. And so the defendant is incorrect in applying that statute because it's a state law violation, not a city ordinance violation.
The court has read the defendant's motion to dismiss, and I have read the state's response to that. And the court is denying the defendant's motion to dismiss. Don't see.
This segment feels like the final warning before impact. The state frames driving as a privilege, not a right, undercutting the jurisdiction argument. The judge denies the no consent motion and carefully outlines jury procedure, strikes, and courtroom expectations. There's no sarcasm, just structure and clarity. The message is unmistakable. Ideology won't override criminal procedure.
Were you prepared an order for me to sign? Let me see.
I did not prepare one, Your Honor, but I will be glad to prepare one.
Okay, if you can prepare one, Mr. Bishop, I will get that signed. I'm writing a notation here. Motion denied. And then we have the second motion, defendants, no consent given. Mr. Elizondo, you may summarize your argument at this time.
Whatever I submitted is what I plead to continue with.
Mr. Bishop, would you summarize the state's response?
Yes, the state's response is in the state of Texas, driving is a privilege, not a right. And by exercising his privilege to drive on a Texas highway or street, he is subject to all rules of the road, statutes, and rules. For him to be subjected to jurisdiction when he has violated a state law. He's not being denied his rights. Driving is a privilege, and by driving, he subjects himself to the rules of the road and other state laws regarding driving.
All right, based upon the court has reviewed the written motion and response, motion by the defense, response by the state, has considered the arguments made here in court, and the court is denying the defense statement of no consent given to jurisdiction. Mr. Elizondo, your case is set for jury trial on Thursday, August 28th at 8:30 in the morning. That is when you need to be here. You have cited in some of your motions civil rules of procedure. As I have warned you before, I'm warning you again, the Texas rules of criminal procedure apply in this case. This is a criminal charge, and you need to follow the Texas rules of criminal procedure. You will be expected to follow proper courtroom decorum, and as you are representing yourself, you will be held to the same standard as if you were an attorney. You need to be here at 8:30 in the morning. You will receive information regarding the venirmen, the potential jurors, and voir dire will start at 9 a.m. You will be given 15 minutes to ask relevant questions of the venire panel. The state will be given 15 minutes to ask questions of the venire panel. Each side is given the opportunity to make up to 3 strikes, and then we will proceed to the jury trial that day. Have any witnesses that you wish to call and any evidence that you wish to present here and ready when you get here at 8:30 in the morning. Do you understand, sir?
Yeah.
Okay. All right. Mr. Elizondo, is there anything else that you wish to put on the record at this time?
No.
Mr. Bishop, anything from the state?
Nothing further from the state, Your Honor.
Okay, Mr. Elizondo, you are released at this time. We'll see you here in person at 8:30 in the morning on August 28th.
Sounds good.
You are released at this time.
This is the outcome. The jury has already spoken, guilty, but the defendant makes one last push with a motion for new trial, repeating the same statutory arguments and claiming deprivation of rights. The prosecution dismantles it point by point, and the judge denies the motion. An appeal bond is set, and the reality becomes final. If you found this breakdown valuable, make sure to like the video, subscribe to the channel, and we'll see you in the next video.